Hi, everyone. Good morning. We're so happy to have you with us today. Thanks for joining us. We're going to get started here. Thanks for being here. Welcome to our legal roundtable. Patrick, could you advance the slide for me, please? We would first like to thank our 2021 Diamond sponsors. Without them, we wouldn't be able to have survived the last year. So we wanted to acknowledge them. CertaPro Painters of St. Charles, South County and West County, O'Connor Insurance, Premier Roofing Company, and the Daniel and Henry Company. Thank you guys again for your sponsorship. We appreciate it. Next, we'd like to thank our webinar sponsors for today. We have Blue Sky Restoration, the Smith Management Group and Associate Company, and Reserve Advisors. And we're lucky enough today to have Reserve Advisors as one of our presenting sponsors. And we'd like to welcome Stephanie and give Stephanie an opportunity to tell us a little bit more about Reserve Advisors. Hi, Stephanie.
Yeah. Hi, thanks, Kathy. Yeah, so glad that I could be here for this. So Reserve Advisors, I mean, we've been around for about 30 years. We complete thousands of reserve studies every year. So we have a lot of local experience. And we're really committed to our clients to finding the best reserve study solutions and guide you guys towards, the future in terms of reserve projects. So, one key point that I just wanted to make is that we are really committed to our clients. And so we offer unlimited support. And so when we complete our reserve studies, we're always open to any phone calls in the future to go over questions when they come up, because as we know, reserve studies get put on the shelves quite a bit. And then the next board comes around and may not understand their current reserve study. So we're always there to partner with you guys and make the most out of the reserve study. So again, yeah, thanks for having us. We're happy to be here.
Thanks, Stephanie. We appreciate your sponsorship. I am going to go ahead and we're going to get started now. So how it's going to work today, since it's a round table, we are lucky enough to have a couple different presenters today. So we are going to ask each of them to introduce themselves and tell a little bit more about themselves, and then we'll get started. So we'll save all the questions at the end. All the presenters will come back for Q&A at the end. So at any point, if you have a question, you can post it in the Q&A or the chat. And me and Patrick McClanahan, our program coordinator for today, we will be monitoring the chat and the Q&A. So feel free to post those questions, but we will save them to the end. So first, I'd like to welcome Megan. Megan, and everybody else, if you guys want to turn off your videos and mute yourselves so Megan can start the presentation. Thank you so much, everybody.
Hi, everyone. Thanks for being here today. So I am an attorney with Elia M. Ellis LLC. I'm sure a lot of you know our firm. We represent over 100 or so condominium and HOAs, associations across the metropolitan area. And I've been doing this about 8 or 9 years, I think, in this area. So we have quite a bit of experience. I know Elia has been doing it for a long time. I won't say how long, but so if you have any questions at the end, feel free to put them in the chat and we'll get started here. So I'll be talking about pet restrictions, pet policies, and emotional support animals and their effect on, I guess, how boards should deal with those emotional support animal requests. I'm sure a lot of the boards have already received these over the past few years. It's a growing concern for a lot of communities. So that I deal with personally, I've had to deal with them. So I thought it was a relevant topic that we should provide some information about. So a lot of communities have pet policies, one or all of these or a combination of them. Limited number of pets allowed per unit, let's say 1 cat and 1 dog. There's pet deposits or pet rent is another policy I've seen. The big ones are breed restrictions and weight restrictions. Some associations don't allow, let's say, a pit bull or a large breed dog. And then some associations don't allow pets at all. And so that's where we can run into a lot of problems with federal law and state law. Patrick. So as I mentioned, the request to keep emotional support animals in condominiums, and we're going to focus mostly on condominiums just because of the way that they're structured, the physical makeup of the communities, but this is applicable to HOAs as well. So the request for these emotional support animals in condominiums with pet restrictions is on the rise, especially with this past year. I know a lot of my communities have received a lot of emotional support animals due to the COVID pandemic and the mental health effect that it has on the residents. So we have seen quite an uptick in these, and I'd say HUD's, their biggest complaint that they see does deal with these requests for emotional support animals too. Patrick. So the federal law that gives us the requirements and obligations of the community association is called the Federal Fair Housing Act. It makes it unlawful for a housing provider to refuse to make a reasonable accommodation that a person with a disability may need in order to have an equal opportunity to enjoy and use a dwelling. So as I mentioned, one common request housing providers receive is for a reasonable accommodation to that pet policy or the no animal policy. So individuals with disabilities are permitted to use assistance animals in housing, including the common areas, like the pool area, and then any other common element areas. Next. So first, there are two types of assistance animals. Service animals, which we're all probably familiar with. It's any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. And those are the dogs that are allowed in public places like restaurants and things like that, because they are specifically trained to do something for their owner or handler. Whereas support animals, they can be really any other type of animal. Service animals are limited to dogs, whereas support animals can be a support peacock like they had on the airplane, a support potbelly pig, anything. They do work and perform tasks, and what we'll focus on today is providing assistance or therapeutic emotional support for individuals with disability. And the reason we're focusing on the emotional support animals is because usually they are required for a mental disability that is not readily apparent to everybody. And so that's where we run into problems if a board asks too many questions, and they can't see the disability. And so it's a lot trickier than if someone was, let's say, blind and had a service animal. But any other animal that does not qualify as one of these two assistance animals is considered a pet, and the pet policies can be enforced against that owner and pet too. Patrick. So real quick, like I was saying, the difference between a service animal and emotional support animal. The service animal is specially trained, whereas emotional support animal is not. And I guess my puggle could be considered an emotional support animal, even though it drives me crazy, but it's that type of situation where it's not trained to do anything for me specifically. It's just there to provide me comfort. Service animals and emotional support animals are allowed on airlines. Again, service animals only allowed in restaurants. Emotional support animals are not. The housing, both animals are allowed in housing. Trained to assist just one person, a service animal. Emotional support animal can be an emotional support animal to multiple people. And the service animal does not provide emotional support, but an emotional support animal does, obviously, and neither of them have to be certified or registered. So you'll see a lot, and we'll talk about this in a minute, a lot of people go online to get certifications or registrations for their animals and present those to the association as proof that it is, in fact, an emotional support animal. Well, so there's no federal database or anything like that, certification or registration for these animals, and there's not required to be one. And so any documentation that someone presents you that says that they are registered or certified is most likely just pulled off the internet and is fake, because there is no such organization that certifies or registers either animal. Next. So now we're going to talk about the obligations of housing providers under the law and the specifics, and kind of how to deal with a specific request when one is made. Patrick, thanks. See, we should have had our signal to pat the head to change the slides. So the FHA requires housing providers to allow reasonable accommodations involving an assistance animal in situations that meet all of these requirements. One, there has to be an actual request made to the housing provider by or for a person with a disability. If there is no request, obviously there does not need to be a grant of a reasonable accommodation, because you're not aware of it. A few things to note though: the request is not required to be in writing. It's not, there's no special language that you need in it, no reasonable accommodation or assistance animal language in there. It can be pretty basic and just say, I need to keep this dog for whatever reason, and then give the disability related reason, et cetera, et cetera. And another thing to remember, a request can be made on behalf of the individual too. So it doesn't have to be the individual with the disability that's asking. It can be their roommate, their family member. And then also the resident can ask for the reasonable accommodation before or after they have the animal. So I've had cases or situations where that was the case. And to me, that shows that they got this animal as a pet and then wanted to keep it in their no pet community, and now they're claiming it's an emotional support animal. And while HUD agrees that that tends to show that there's bad faith on the part of the owner requesting that animal, and as a emotional support animal when in fact it's a pet, that's not necessarily conclusive, because they have the right to ask for it whenever they want, before or after they get the pet. So don't just assume that because the request comes after they already have the animal, that it's not a legitimate need for that animal. So next we're talking about the different criteria for assessing whether to grant the reasonable accommodation request. And so this is where on the next, don't skip slides, but on the next slide, we're going to have like a chart, a flow chart that shows these steps that the board, these questions that the board should ask. And if yes, go down to the next one. If no, you don't have to grant the reasonable accommodation. And that's important too. But real quick, before we go to that slide, Patrick, so if someone is blind and they're requesting a service dog, you can't ask for the documentation. The disability is readily apparent. And so you need to grant that reasonable accommodation then and there. So like I said before, with the mental disability, it's not readily apparent. And so only then you can ask for documentation to support that reasonable accommodation request, which would be any documentation that there is a disability or the disability related need for that animal. And so usually individuals get the documentation from a physician, any sort of mental health professional, any sort of professional really that can document the need for, well, the disability, and then also the need for the emotional support animal. So usually people just go to their primary care physicians I've seen, and it needs to be on their letterhead so we know it's official and things like that. And there's some guidance we'll send links to that you can take with you, that CAI has produced a really good summary of all the steps that you need to take. So I'll provide that link here in a little bit. So like I said, if there's not a readily apparent disability, you can then ask for documentation. And the documentation, it serves the purpose of verifying the condition that substantially limits one or more of the residents' life activities, which caring for oneself is one that's usually affected by mental illness. Leaving the house, things like that, if they, are afraid to go outside, things like that qualify as a condition that limits a major life activity, which is the definition of a disability. So then the documentation also serves a purpose of describing the need for accommodation or the needed accommodation, which would be allowing that animal in the no pet community. And then this is an important one. The documentation needs to demonstrate the relationship between the person's disability and the need for the requested accommodation. With emotional support animals, I find that it's a fine line between what the relationship or what the need for that animal would do to help their mental illness. It has to alleviate an effect or a symptom of the disability. And so you usually have to just take it as face value, what the physician's note says, that it is an accurate description of the need for that disability. Because obviously we're not medical professionals and we can't make that determination. So we do take it at face value. Patrick, you can go to the next one. So here is a chart that CAI put together based on HUD's 2020 guidance, making it a little bit easier for boards to know how to make the decision when they're approached with the reasonable accommodation request. And like I said, we'll just walk through it real quick. There needs to be a request to begin with for the reasonable accommodation in connection with that physical or mental impairment or disability. So the request would look like, I need this emotional support animal to live with me, even though there's no pets allowed. If the person has an observable disability, or you already know that they have this disability, if they have it, you don't ask for documentation. You just need to make sure that the animal is a support animal, as we defined earlier, and then you grant the reasonable accommodation. If the disability is not readily observable, you can ask for additional documentation, which includes the physician's note. Like I said, the internet documentation alone by itself is not sufficient. So a certificate saying that this is a registered ESA, that's not sufficient by itself. I would recommend that the person get a physician's note, which they usually already come to you with that in hand when they ask for the reasonable accommodation. So then once you have the documentation, then you can decide if there's an exception to, so let's say the documentation does support that they need the disability related accommodation. Unless there's an exception, you have to grant that accommodation. An exception would be something like the pet is dangerous. So if you can't come up with an alternative accommodation that would ensure the safety of residents, let's say someone wants an alligator and to keep in their apartment size condominium, that obviously is not reasonable. You shouldn't deny the request right away, but you should recommend a different accommodation, such as, you know, maybe a gerbil or something like that. And then another exception to the requirement to grant the reasonable accommodation would be if there's a financial burden put on the association. And there's really, I guess, if they would have to change the layout or structure of the condominium to accommodate this person, that could place a financial burden on the association. It's very fact specific. And each of these, I should say, needs to be addressed in their own right. There shouldn't be a blanket policy on the disability related accommodation requests. It should be judged on the individual basis as these come up. So there's the direct threat. If the keeping of the animal would be cause significant physical damage to the property, that is also, excuse me, an exception. But I mean, these have to be verifiable exceptions that documented that the animal poses a direct threat, that the financial burden is too great for the association, and that they would in fact cause that physical damage. Let's see. Okay, Patrick. So the overall consensus is these usually go against the board. I know a lot of boards want to enforce their policies to the T, but if they are approached with these reasonable accommodation requests, they generally need to grant them after obviously reviewing it with counsel if you think necessary, because federal law, excuse me, federal and state law are fairly strict on this, and the fines can be quite significant if you're found to be in violation of these laws. With that said, though, there are new laws coming out that, excuse me, I apologize. There are new laws that are helping any housing provider deal with these fraudulent requests for assistance animals. And so Missouri does have a law that was recently passed that prohibits anybody posing as someone with a disability and makes it a misdemeanor crime if it's found out that they in fact don't have the disability and don't need the emotional support animal for that disability. So we are taking steps to limit these fraudulent requests, but they still are very prevalent. And that's it.
Thanks, Megan.
Thanks.
Sarah, you're up.
Hello, everyone. Good morning, and thank you for joining us today. My name is Sarah Beltman, and I'm the principal at Gateway Law, STL. I've been practicing community association law since 2006, and I'm going to talk to you today about harassment and hostile environments within community associations, and how HUD regulations place a burden. Patrick, we're not that far yet. I'll tell you when to advance the slide. Thank you. How HUD regulations place a burden on the associations to avoid harassment and hostile environments. The Fair Housing Act makes it illegal to harass persons because of race, color, religion, sex, disability, familial status, and national origin. We'll go over when an association is liable, criteria that HUD uses to evaluate complaints, tools for the board, steps for preventing a hostile environment, and also the community impact of hostile environments. So let's get started. Next slide, please. We typically think of harassment in hostile environments relating to our places of employment as opposed to our places where we live. But in 2016, HUD adopted amendments to address both quid pro quo and hostile environment harassment with respect to a housing context. These changes provide an opportunity for a community association to be responsible for hostile environments, even as a third party, meaning that they're not the ones, the board is not the individuals doing any harassment. So that's what I mean by as a third party. For many years, boards have avoided intervening in what we call neighbor versus neighbor disputes. Given this change in the HUD regulations, however, boards may need to do just that, to intervene if the dispute is quid pro quo or hostile and harassing in nature. So quid pro quo means this for that. And again, usually we think of that in a employment type of context. If you do this, that, or the other, then I'll give you your raise. And this, that, or the other usually involves something inappropriate. And a hostile environment, HUD defines as an unwelcome act or unwelcome conduct that is sufficiently severe or pervasive, and that conduct interferes with the use or enjoyment of services or facilities. And next slide, please. Some examples of hostile environment harassment within an HOA include displaying racially threatening flags or symbols that other residents may find offensive based on their national origin or their sex or race, color, religion, or their disability or their familial status. Another example would be threatening emails or messages sent out to residents, and also public commentary and verbal intimidation. I myself have had clients with situations such as this all in the past year for sure, that these types of scenarios play out in our communities, and it becomes more and more prevalent, it seems, as time goes by. The next slide, please. So the complaint submitted to HUD, it will contain an allegation that harassment did occur. It will allege that the HOA or the board knew about this situation and behavior, or that they should have known about it. that the HOA had the power to correct or end that harassment. And lastly, that the HOA failed. They failed to take prompt action to correct or otherwise end the conduct. Factors in analyzing the complaint. I'm sorry, next slide, please. So factors in analyzing the complaint include context, severity, scope, frequency, duration, location, and the relationships of those involved in the conflict. So these, go back to the previous slide, please. So these are the factors that the HUD investigator will evaluate in analyzing the facts and circumstances surrounding the complaint. And depending on the situation, some of them may carry more weight than others. These types of complaints they're very case by case, and should be analyzed on an individual basis. Frequency and duration are obviously important if this is a harassing behavior that happens every single day, compared to a single day. That frequency will play a large factor in the analysis. However, a single severe incident could be enough to constitute a hostile environment. The next slide, please. So tools that the board has available, those will vary from community to community. And that usually depends on the authority in your documents. If you're a condominium association, you'll have the authority that is that can be drawn from the statute itself. But basically, this will be very document driven as far as how the board can address the situation. And you'd want to get with your attorney to devise and implement a strategy for dealing with the situation as they develop to avoid liability. So some of these tools would be a notice of violation, imposing monetary charges or fines, suspension of privileges, and that would be a spin-off from your notice of violation if you have the authority to withhold amenities, pool access, voting privileges, things like that. If you have the authority to suspend those privileges if an owner is in a state of violation with the governing documents. If these methods don't work, you may be compelled to file a lawsuit and or perhaps invite the parties to participate in mediation. Mediation and lawsuits are expensive, but in evaluating your power to address the situation, you want to take steps to show that you at least tried to mitigate the situation in order to protect the association in the event that a complaint is made. Now, in devising and implementing strategies, again, that would be case by case, not necessarily this is how we deal with these situations absolutely every time. Because, you know, on the previous slide, would you go back one, Patrick, please? Thank you. These are, I mean, that's seven factors to evaluate. And so if you're dealing with something that happens with much frequency compared to something that is a single event, a single harassing event that is severe, that is, those would require two totally different approaches in addressing the situation, based on what's even going on. And that relationships also, if you've got neighbors next door who are husband and wife, and it's their hostile family environment, you know, that would also be taken into account in the analysis. So advance the slide, please. So in determining what tools you should be using, remember the elements that there is a claim of harassment, okay? And that the board knew or should have known. So if the board knew or should have known, is the board receiving repeated complaints or even one complaint from an owner about a situation? So do they actually know because they've received complaints, or should they have known? So in the example of a racially discriminating flag in someone's yard, the board should know about that, more than likely, depending on the size of the subdivision. But that would be an example of should have known, because it's right there in their yard and in plain sight. And then did the board have the power or the tools to address the situation? And again, that's where you want to get with your attorney and determine what tools do you have and what is the best approach for dealing with this particular situation. Because that last element is that the board didn't. The board had the tools, the power, the authority, and the board failed to take any action. And sometimes that action might be as simple as a notice of violation or a cease and desist letter that would just put the kibosh on the hostile situation. Next slides, please. So some steps that you can take as a board toward preventing a hostile environment in your community is adopting a non-discrimination policy and taking the CAI Civility Pledge. The CAI Civility Pledge is available on the CAI website, and it references the rights and responsibilities of owners as drafted by CAI, which is a really great document. It goes over just a lot of basic, it's in bullet point format, where what basic rights do homeowners have as far as fair treatment and participating in meetings and accessing records. So the document's broader than just how do we treat each other. But it also goes over the responsibilities of the homeowners, to pay assessments, to comply with the governing documents, to respect the privacy of board members, and then the rights that the community leaders have and the responsibilities that the community leaders have. So it integrates those basic, how to act like a courteous, responsible neighbor within a community association. I would encourage you all to take a look at those documents and see if that civility pledge can be incorporated into your community. And taking a civility pledge is not necessarily going to prevent some jerk down the street from acting like a jerk. However, the more respect that we treat everyone with and make it public within our community that acting with civility is important to our community, it helps to foster a more caring and open community that's more likely to communicate than to harass. Next slide, please. So your community impact, if you're, even without a HUD complaint on harassment and hostile environments, if there is a hostile environment, you're obviously going to foster tension and unrest in your community instead of a cohesive type of living environment. But from a practical standpoint, with a HUD complaint of this kind, the association becomes open to monetary damages, if any were incurred by the complainant, but not to mention the attorney's fees associated with defending such a claim. Insurance may cover to defend under your D&O policy, but it also may not. So that depends on your policy. However, even if it is covered, if reasonable cause is found and determined by HUD, then you will, your coverage there would be no coverage. Coverage would be excluded in such a situation. And so then you are open to punitive damages that would or could be imposed by HUD as well in order to punish the association for allowing or provoking, perhaps, again, depends on the circumstances of the complaint. So you're open to attorney's fees, monetary damages, punitive damages, not to mention the tension and unrest that other neighbors have living in a community of hostility. So those are things to take into account and keep in mind when you are becoming aware or should be becoming aware of a potential situation that the attorney's fees associated with a consultation and devising and implementing a strategy are a lot less than the attorney's fees and potential exposure that the board has if they fail to do that. So I would keep that in mind when you don't feel like spending the money to call the lawyer to deal with a situation at the forefront of the problem instead of at the when you're forced to deal with it because a HUD complaint lands on your desk. So and that is all I have. So I will pass this on to Rod Hoffman. Oh, I'm sorry, Malika.
I'm sorry, Malika, you are muted. No, you're fine.
I am Malika Jones, and I am a lead equal opportunity specialist with the U.S. Department of Housing and Urban Development. I'm actually an investigator with HUD. What I do is I investigate housing discrimination complaints. And I tell my housing providers all the time that when you see me, you know, it's not an I got you, or it's something to take seriously, because when a person contacts our office with a complaint, we take it very seriously, but it's never an I got you. I'm an impartial party, and I conduct my investigations based upon the facts. So when you as a housing provider receive a complaint, I will contact you. I'm going to give you a little bit of information regarding the investigative process, so you will understand. Once a person files a complaint with our office, I will contact you as the investigator. I will conduct interviews with you and your staff. I will conduct an interview with the complainant to make certain that, you know, we have jurisdiction to investigate their allegations. The Fair Housing Act prohibits discrimination based upon 7 protected classes. Those are race, religion, sex, familial status, which includes women who are pregnant, national origin, and handicap. The Fair Housing Act actually states handicap, but we normally use the term disability because it's handicap. The word handicap has such a negative connotation. So those 2 terms, handicap and disability, are used interchangeably, okay? Let me give you a little history about the word. The reason that we don't use the word handicap any longer was because the term used to refer to an individual standing on a corner with a cap in hand requesting money. So that is the reason we started referring to persons with disability as people with disability as opposed to being handicapped. My previous presenters have done such a wonderful job. It makes my job so much easier. I was going to speak about reasonable accommodations. So I'm going to give you a little bit of information about reasonable accommodations. You can move to the next slide. I have been with the department for 18 years. Let's see, Sarah was talking about hostile environments. I had one of my major cases, which was a case that we settled for $625,000, was based on sexual harassment and hostile living environment. So she's correct when she is telling you that when these cases are brought to our attention and we determine that discrimination actually occurred, the housing provider there's generally a monetary settlement. Okay, next slide, please. The authority to investigate housing discrimination complaints was given to us by Title of the Civil Rights Act of 1968 as amended in 1988. Next slide. No person shall be subjected to discrimination in the sale or rental of housing, again, because of the 7 protected classes. Next slide. What type of housing is covered? The Fair Housing Act covers most housing. In some instances, the act exempts owner-occupied buildings with no more than 4 units. Let's say you have a 4-family flat, and as the owner, you live in one of the units. That's considered an exemption. You're exempt under Miss Murphy's Law. It also covers single-family housing sold or rented without the use of a broker, and housing operated by organizations and private clubs that limit occupancy to members. Next slide. What is prohibited? It is prohibited to refuse to rent or sell housing, refuse to negotiate for housing, to make housing unavailable, to set different terms and conditions or privileges for sale or rental. And again, based upon 1 or more of the 7 protected classes. You cannot provide, you cannot provide different housing services or facilities, deny that housing is available for inspection, sale, or rental, persuade owners to blockbusting, which is persuading owners to sell or deny anyone access or members to a facility in the ML. I can't read the rest of it. Next slide. Okay. Establishing a disability under the Fair Housing Act. Next slide. A handicapped or a disabled person is an individual with a physical or mental impairment which substantially limits 1 or more of the person's major life activities. A record of having an impairment or being regarded as having an impairment, but such term does not include current illegal use or addiction to controlled substances. A disabled person is someone, again, with a mental or physical impairment that limits 1 or more major life activities. Major life activities include seeing, hearing, speaking, working, manual things. The act does not protect juvenile offenders, sex offenders, illegal drug users, persons with disability who pose a significant danger to others. The Fair Housing Act does protect recovering addicts and people who may pose a danger to others, but a reasonable accommodation can be made to mitigate the threat. Section 804F9 states, nothing in this subsection requires that a dwelling be made available to an individual whose tenancy would constitute a direct threat to the health or safety of other individuals, or whose tenancy would result in substantial physical damage to the property of others. What is a reasonable accommodation? It's very simple. It's a change, exception, or adjustment to a rule, policy, practice, or service that is necessary for a disabled person to enjoy a dwelling and common areas. Accommodations must have, and I emphasize this, must have a relationship or nexus to the person's disability. Examples of a reasonable nexus include granting an exception of a policy of providing first come, first served unassigned parking spaces to a person with a mobility impairment. Say your tenant is mobility impaired. He's made you aware of that. And you notice that he has a placard in his car window, and he requests an accommodation of having a parking space near his unit. You can grant a reasonable accommodation. Okay, another reasonable nexus is a tenant with a phobia of leaving their unit. You can grant an exception of requiring that if you require as a housing provider is that rents or payments be made in person in to the management office, you can grant a reasonable accommodation allowing this particular tenant with the phobia of leaving their unit to mail their payment in. Another example is granting an exception to the no pet policy and permitting a service animal to live in a unit if the tenant has a disability, a hearing disability. Reasonableness of the accommodation are always made on a case-by-case basis. The cost of the requested accommodation is taken into consideration. The financial resources of the housing provider is also taken into consideration, and the benefits to the tenant that the accommodation would provide. Availability of alternative accommodations that would effectively meet the requester's disability-related needs. As the previous presenter stated, if your tenant comes to you requesting an alligator for an emotional support animal, you may, as a housing provider, suggest that this tenant look into other animals, such as maybe a dog would suffice. You are giving an equal alternative solution to the tenant's request that would meet the disability-related need. If a provider denies a request, it should meet with the requester and engage in interactive discussion to determine if an alternative option is available. I tell housing providers to do this all the time because that's normally where you make your mistake. You either a person comes in and requests a reasonable accommodation and you don't reply. That constitutes a denial under the Fair Housing Act. Okay, so you always want to, even if you're going to deny the request, you want to engage in an interactive discussion with your tenant to see if there is an alternative option available. If the request is reasonable, again, if the request is reasonable, the provider can propose an alternative so long as it is equally effective. The tenant is not obligated to accept it. Next slide. A failure to reach an agreement after the provider has engaged in interactive discussion still constitutes a denial. The person still has the right to file a fair housing complaint. But if you've done all that you are required to do, when you see an investigator come to your office or contact you, you have nothing to worry about. An applicant or resident is not entitled to an accommodation, and you heard this from the previous presenter, unless he or she requests one, or unless then a request was made on behalf of the disabled person. Say that, for instance, my mother is disabled and she lives at your property. I can come as her representative into your office and make a request for her. A request is made when a resident or an applicant makes it clear to the housing provider that he or she is requesting a reasonable accommodation or an exception, change, or adjustment to a rule, policy, or practice because or based upon their disability. The request should explain what the desired accommodation is and the disability related need. Next slide. Okay. I'm going to tell you some other things that I see in a lot of our complaints that we receive based upon disability. A lot of housing providers will, again, not contact the requester right away because they're not sure how to respond to the reasonable accommodation request. So they will delay responding, and that's going to, that causes a problem for the housing provider. Housing providers cannot impose additional fees or deposits as a condition for requesting a reasonable accommodation. I have had housing providers come to me and say, Ms. Jones, this dog is so big, and I've told the tenant that they can have a larger dog, even though our policy states that we only have small dogs. But I think that this dog is really going to do some damage to my unit because I've seen those types of things before. You cannot, as a housing provider, make that assumption. If the tenant's dog causes damage to the unit, then you are allowed, as the housing provider, to issue a violation, just as you would a non-disabled tenant. What the Fair Housing Act is trying to do is basically level the playing field for disabled tenants. You treat your disabled tenant as you would a normal non-disabled tenant. If the disabled tenant is not picking up after their dog, and you give them, notice that this is what needs to be done, and the disabled tenant refuses to do that, you issue a notice of lease violation. Okay. When can a housing provider deny a request for a reasonable accommodation? There are three different ways. When the request, again, is not made by or on behalf of the disabled person, when there is not a disability-related need established, meaning the doctor's or physician's note that you receive does not have a nexus. There's not a relationship between what the tenant is requesting and their disability. Then I normally tell my housing providers, you are free to ask for clarification. You cannot, a doctor or a physician or a healthcare provider is not required to give you a diagnosis, but they can tell you why this particular tenant needs this reasonable accommodation. You have a right to know that. And thirdly, when providing the reasonable accommodation is not reasonable, it's an undue financial or administrative burden on the housing provider, or would fundamentally alter the nature of the provider's operations. For example, if you have a tenant who needs to be taken to the grocery store, and so she comes to your office requesting a reasonable accommodation of having someone from your office take her to the grocery store to run errands. You do not do that for any of your other tenants. Therefore, you are not required to do that for that disabled tenant. You will talk to the tenant and you will explain your decision and your denial of their request. Making the request for reasonable accommodation. The request does not have to be made at a certain time or in a certain manner. A lot of housing providers now have a form, a reasonable accommodation form that they like for their tenants to complete and return to the office. I am not required to, as a disabled tenant, to complete your form. As long as I've made you, the housing provider, aware that I have a disability and I have a disability-related need for my request, Generally, that is the disabled person will provide you with a healthcare provider's letter. But you cannot require me to complete your form. If I make a verbal request for reasonable accommodation and I don't put it in writing, then you still are required to take into consider my request. Again, if the provider fails to respond to a request for a reasonable accommodation, that constitutes a denial. I also wanted to talk to you about some of the things that we are currently seeing. And these are internet provider letters. A lot of the tenants are now going out on the internet and getting, they're calling them healthcare provider letters, but they're actually some companies out here which tenants can pay for and a letter, and they will generate a general letter. The department has determined that that is not the internet letter in itself is not sufficient for is not reliable to establish that this person is in need of a reasonable accommodation. So if you have a tenant who brings you one of these internet issue letters, what you need to do is see if that tenant will provide you with a healthcare provider that they have been, one of their primary care physician, another physician's letter. You have the right to ask for that as a housing provider, but that's only if you believe that the physician's letter or the healthcare provider's letter is not legitimate. Okay. Keep in mind that housing providers have the right to ask for clarification. Again, if you cannot determine that the request and the nexus is not clear to you, you don't have to ask for a diagnosis, but you can request clarification. How is this going to assist you with your disability? Could you have your physician put that in writing? I tell my housing providers all the time that it is imperative that you document. Anytime that you receive a reasonable accommodation request, you want to have, I spoke with Ms. Jones on Friday, September 5th, regarding her request. I told her I would get back with her. I didn't have an answer right away. I wanted to speak with my attorney. You want to document these things. So when I do end up in your office with my investigator hat on, you have documentation to show me, or you have some type of evidence, because that's when I'm on site doing an investigation, I'm looking for evidence to support your assertion that you did not discriminate. Okay. I also wanted to talk about, we're starting to see a lot of, I will let Mr. Hoffman deal with the pool thing, and I will jump in if needed. We're starting to see a lot more complaints come in about regulations regarding pool practices. I will tell you that yes, Megan, did you have a question? I will.
Oh, sorry about that.
That's okay. When I first started working for HUD back in 2002, I was a new mother. I had a 1-year-old, and I was hired through our main office, our main regional office, which is in Kansas City. I am originally from St. Louis and was living in St. Louis. So I went to Kansas City so I could get the job experience. while I was in Kansas City, and I tell my housing providers this example, I provide this example a lot because it gets you thinking, because it got me thinking. And I was a new investigator. I had not read all the regs, but I was out looking for apartments to rent because I was going to bring my 1-year-old, once I got settled, with me to Kansas City. And I talked to several housing providers and I told them, okay, I'm moving here with my 1-year-old. And a lot of housing providers told, oh, no, that's fine, Ms. Jones, but what we're going to do, we're going to have to offer you a first floor unit because, we have balconies here and we don't want your child to have, we don't need a safety issue. Well, I went back to my office and I'm very excited. And I'm talking to my supervisors about these units that I'm going to view. And they told me, Malika, you didn't hear what you just told me. And I said, what do you mean? They're offering me, a unit. They're offering you a ground floor unit based upon the fact that you have a child under the age of 18. The Fair Housing Act prohibits discrimination based upon familial status. That includes pregnant women and legal custody of people or persons under the age of 18. A lot of complaints have been coming in regarding pool restrictions or, a lot of condo associations have policies that children under the age of 18 cannot be at the pool without an adult. The Fair Housing Act, under the Fair Housing Act, that is discriminatory. I will tell you that. We have determined that there is a way to, we understand that it is a safety, I'm sorry. It is a safety issue, and we have determined that it would be the housing provider is allowed to have a less restrictive means to achieve the desired effect. So it would be okay under the Fair Housing Act if you had pool restrictions for, say, children under the age of 13. Because let's look at this. I can be a 15 or 16-year-old and I can be a lifeguard. Should I be then required to have my parent with me while I'm performing those duties? I also want to make sure that housing providers, a real easy way to know if you are doing the right thing is to look at the Fair Housing Act. There are 7 protected classes. Say that what you could do is insert one of the other protective classes in place of the protected class that you believe that you may be discriminating against. Say race. Would I restrict African Americans from being at the pool? No, that would be a violation of the Fair Housing Act. Familial status is also a protected class under the Fair Housing Act. Therefore, that constitutes a violation. Having children and, the elderly, they prefer to be in the back of the complex. No, that's discriminatory also. You cannot segregate your tenants based upon protected classes. If people are requesting to be in a certain section of your housing, that's different. But you cannot make an assumption that certain people are, more likely, there's more noise up front. Therefore, we should put, elderly in the back of the complex. They would be more comfortable there. Segregating based upon protected classes is a violation of the Fair Housing Act. We are available in the St. Louis Fair Housing Office to answer and to provide any technical assistance that you may need as housing providers. I know that you generally rely on counsel, but if you have any questions that you don't want to run by counsel, that you feel that our office, you feel funny about a policy or a practice that you want to put in place for your tenants, feel free to contact our office and we can provide you with technical assistance. And I think that's the end of my time.
Thanks, Malika. We appreciate you being here.
Sure.
Rod, it's your turn.
Good afternoon, everybody. Thank you all for letting me speak to you. I'll be fairly brief. You've had three great presenters and it's a pleasure to join the panel. I want to talk about two things. The first is defending these claims. And I think Sarah and Megan will agree with me that we're not here to provide legal advice to you because, as Sarah said, almost all of these things occur on a case-by-case basis, and we can't find one instance where we can say this is how to do it. But there is one thing that I want to suggest to you all. It may not work, but I would recommend that you contact your insurance agent for your homeowners association fairly quickly and ask if you can buy some sort of coverage that defends claims involving discrimination or HUD claims. I think most likely the insurance companies are saying discrimination is an intentional act and we don't cover intentional acts. But the reason I want you to investigate it is defending these claims. If there is a claim and you want to get an attorney involved, they take time and they can be expensive. To the extent that you can have insurance coverage for them, you're much better off. 10 or so years ago, we had one here in the Kansas City area where a resident complained that she was being discriminated against. HUD said there was no discrimination, but HUD said that she can still file her own lawsuit. She filed a lawsuit in federal court by herself without an attorney. It took about a year. The judge finally dismissed the claim and said she didn't have a case. The homeowner, the resident, she wasn't a homeowner, appealed to the 10th Circuit Court of Appeals. It took a while, but the 10th Circuit Court of Appeals agreed that she didn't have a case. She asked the US Supreme Court to consider her case. Fortunately, in that case, the association had an insurance policy that covered the claim and provided a lawyer to defend that throughout that process. But I'm sort of guessing that insurance companies have said no more, but I would certainly advise you to see if that's possible. What I want to talk to you a little bit about is the process. We're very fortunate to have Malika as a resource, and I would certainly encourage you to visit with the local office if you have questions. Malika said that she is an impartial investigator, but what happens when you receive a complaint from a HUD office, you'll receive a formal letter, it's about 5 or 6 pages, from the regional director of HUD saying you are the named respondent in a complaint. They'll attach a copy of the complaint filled out by the resident or the homeowner, and the letter will say you have 30 days to answer this complaint. And HUD will say we have 100 days to investigate, and they will do their job. The next thing after you put together a response to the complaint, HUD will follow up with another letter, most likely saying, thank you, we want to see the following documents. So if it's an architectural issue, they may want to see all architectural requests of a similar vein over the last 5 years. If it's another issue, they may want to see other documents. They want a list of all the people that you are aware of that could have knowledge about this, and you need to respond to that in a timely fashion. And then you'll receive a phone call or an email from the HUD investigator asking to interview these folks. And you as a property manager could be the named respondent. You as a board member could be the named respondent. Oftentimes it's the homeowners association that's the respondent, and you'll have to provide the names and contact information of the board members who will be interviewed. I've seen instances where the HUD investigators will actually come to the kitchen table of a self-managed homes association and sit down with a laptop and interview a board member, take notes. Sometimes they'll go to the conference room of the property management company. Sometimes they'll go to the clubhouse where the resident lives and interview people. Now, because of COVID, they're more likely to do these interviews over the phone. But I can imagine post-COVID, we're going to get back to personal interviews. I've seen cases where we'll be in interviews. They're not like depositions. They're not recorded and they are not transcribed with the court reporter. But an interview with one person can last 2 hours. The next interview may last an hour and a half because the investigator has already covered some of the basics. And the next interview may take only an hour, but with 3 interviews, you could spend from 1 o'clock in the afternoon till 6 o'clock in the afternoon easily. And then the investigator will come back probably after a while and send out a proposed conciliation agreement. And this is another formal agreement that says, here's the allegations, here's the response, here's a proposed agreement. They call them conciliation agreements. I call them settlement agreements. And you'll be surprised that oftentimes in the proposed settlement agreement, it's all the terms that we already knew were going to come down the pike at the beginning of the investigation. These are the terms requested by the complainant, and they want some sort of remedy. Could be money, it could be a change of the rules, it could be that reasonable accommodation. It could be a variety of things. One of the things that will appear in there is a requirement that all of the board members agree to participate in at least 2 hours of training over discrimination as part of the settlement. That causes a little bit of heartburn sometimes for board members to say, wait a minute, we didn't do anything to discriminate. One of the things I want to remind you of is that during this process, we have to be a little bit careful about what we say. We want the whole community to know that there is an investigation. We have to be transparent, right? But at the same time, we have to make it sure that this report to the community doesn't appear to be bitter in any way, because that could be a retaliation claim that could further ensnare us in this investigation. So be careful about how you identify the claim and the status of the claim if you feel compelled to report that to homeowners. And I think at least homeowners are entitled to know that, hey, there's a discrimination claim out there. We're participating and cooperating with the investigation. If HUD finds discrimination, Malika is the better resource. My understanding is they prepare a report, send it to Washington, ask for a review in their headquarters there, and then come back and can determine whether or not there was a discrimination complaint, or a valid complaint. If there's no conciliation, HUD may file the lawsuit on behalf of the resident, or if there is a finding of no discrimination, the HUD may say, homeowner or resident, you still have the opportunity to file your own federal lawsuit. I have not touched here on the Missouri Commission on Civil Rights. We could talk about that at a later date, but now I want Patrick to go to the first slide, and I want to give you some examples of how you can all of a sudden be party to a discrimination complaint without understanding how it happened. This is obviously a nice air conditioner unit, but I'm only using it as an example because about 5 years ago, we had an elderly homeowner live in a condominium community. First thing she asked for was a handrail. Well, we all understand that if there's 2 steps and there's no handrail, that's a reasonable accommodation. It doesn't cost too much and it makes sense. This particular homeowner had a respiratory issue, and I think she was using oxygen. She complained about the air inside her unit and didn't feel that the filtering system was providing clean air inside her unit. She believed that the association wasn't doing a good enough job of cleaning the weeds, the leaves, the grass, and the wood chips around her air conditioner unit, and believed that that was contributing to the poor quality of air inside. The property management company tried to explain that, in their opinion, that the air filtration system on the inside of her unit wasn't related to this unit on the outside. But that didn't prevent her from filing a discrimination complaint. She said that she was being discriminated against based on her disability, that oxygen, that respiratory issue. She withheld her dues. It was a difficult issue. We didn't reach the conclusion of that one after 3 interviews. Unfortunately, for everyone involved, the resident did pass away, but it was an eye-opening experience how something as simple as an air conditioning unit could lead to a discrimination complaint. Next slide, please, Patrick. Some of you may, in the single family communities, may have restrictive covenants that say no trampolines, or you may have a restrictive covenant that says only in-ground trampolines, or no trampolines without written permission. We had one in one of the suburbs where a homeowner put up a trampoline. He received a letter from the property manager that said, hey, we don't allow above ground trampolines in our community. The unfortunate thing was that the homeowner had 2 sons, and more unfortunately is they lived next to a community that did allow above ground trampolines, and they're saying to themselves, obviously, well, why is it that this homes association that appears to have the same name as ours, maybe it was called Pine Ridge instead of Pine Ridge, whatever the, how common those similar names can be, where they're above ground trampolines. The homeowner filed a discrimination complaint based on the disability of one of the 2 sons. And he explained in the complaint that his son has a very rare disease and his doctor had prescribed lots of leg exercise, and that required an outdoor trampoline. We had interviews with the property manager, the developer who was still in control, and the developer's on-site representative. Lengthy interviews saying that there was no intent to discriminate based on a disability. We simply didn't know the child was disabled. We never received a letter. It took a long time, but about 6 months later, the investigator dismissed the complaint. The homeowner had apparently made that whole story up about a rare leg disease and a doctor's note that required a trampoline. But it was expensive to the Homes Association, and because of the fact that HUD's investigation is so thorough, it caused some concern. Next slide, Patrick. This is a common issue where you'll have restrictive covenants regarding parking in driveways or parking on the street. So I can remember sending a letter to the homeowner saying, hey, the restrictive covenants say all parking must be in the garage, or you can park 1 car overnight. Without protesting back to the property management company or to the Homes Association, the homeowners filed a complaint saying that they were victims of discrimination based on their familial status. They had a large family, and every adult or a 16-year-old had a car. Well, they needed some place to park them. The complaint was dismissed again by HUD, or at least HUD wrote a finding back to the homeowner and said, you bought a home with a restrictive covenant. There's no discrimination there. You were aware of that. But that one, fortunately, didn't have a long shelf life compared to the others that I talked to you about. Patrick, next slide, please. Malika already talked about this. This came up in another suburb last year, and you've probably already seen this, where homeowners associations, especially those without staffed pools, were concerned about social distancing, whether they should even open their pools to use. We had a community with a large pool, very attractive pool, but no staffing. They didn't want to get crosswise with local regulations, federal regulations, or state regulations involving social distancing. So they adopted a rule that said no one under the age of 18 can attend without a family member. One homeowner complained and said that was discrimination against families. And as Malika indicated, it does create a problem, because in the same community, the city and the state and county allow lifeguards to be 15. Well, if you can have a lifeguard at age 15 that is a very qualified swimmer, how do you explain that to a 21-year-old who may not know how to swim? So what seemed to be very innocuous rule to help us cope with COVID became subject to a discrimination complaint, and we've had lots of interviews. We are not done with this one, but I wanted to let you know. Next slide, Patrick. You know, in the suburbs where I live, we call most home colors beige based on the name of the suburb, because there's not much difference between them all. And so when somebody paints a home that is sort of outside of that pretty earth tone palette, then the neighbors say, hey, wait a minute, what's going on? And about 10 years ago, we had a homeowner who hired a contractor to paint a house, basically a turquoise color. In the suburbs, without a lot of shrubbery around it, it stuck out. The property manager went out right away after being notified, asked the contractor and the homeowner to stop and submit an architectural request form before you go any further. Of course, the painting continued. The painting was complete. Well, that creates a next problem for enforcement. The Homeowners Association filed a lawsuit and said, homeowner, you have to file an architectural review application before, and if you would have done it, you probably wouldn't have been allowed to paint your color, the color you did. We had a trial. The trial judge made a determination that the home color could stand. I'm not going to get into the reasons, but he allowed it to stand after a half day or a day trial. Afterwards, I don't remember how long it was, maybe a few months, the homeowners who were the defendants in that case were driving around the neighborhood, 700 homes, and they discovered at the end of a cul-de-sac, fairly well guarded by landscaping and privacy, a home that was nearly the same color. None of us were aware of it at the time of the trial. Certainly their attorney wasn't, they weren't, but guess what they did? They were a minority and filed a complaint. They said they were being discriminated against based on their race. Again, who would have thought that that would happen at the late stages? Again, it was just a bit of a surprise and a learning lesson to all of us. I don't know if I've got any other slides, Patrick. Is that the last? Yeah, I think so. So let's go on to the, so I'm going to change hats on you completely. I know you're ready for lunch. I want to talk to you a little bit about legislative action in Jefferson City. We are very fortunate that CAI monitors every bill that is introduced to the legislatures in Kansas and Missouri. And even today during the program, I received an update from CAI National Office about the status of legislation that is pending in Missouri. We're also very fortunate that part of our dues in our Heartland chapter help pay for a lobbyist who helps keep an eye on these bills. He is currently monitoring about 12 bills that could have some impact on homeowners associations. Some of them are duplicate. For example, there are 2 bills that say that solar panels must be allowed on roofs under certain circumstances. That one's been introduced every year for the last 5 years. For some reason, it doesn't have legs. There are a couple of bills this year that talk about COVID and whether or not there should be any immunity from lawsuits over COVID. That could or could not have some impact on us, particularly in the high-rise communities. Another bill was kind of sort of out of the blue from a representative in St. Louis that said, if I live in a home that has restrictive covenants, the homeowners association and the other homeowners can't do anything to modify those covenants on my property unless I agree. For lawyers, we're saying, wait a minute, that sort of flies in the face of what we consider contract law, property law, the rule of law. But it happens that these things do arise because homeowners are, as you know, they can be upset with their homeowners association, something that's happened. And also we have legislators that are often saying, yes, I'll introduce that bill. Whether the legislator actually has some willingness to go forward with it, we don't know. But fortunately, we have a committee and we have this lobbyist that keep up with those things. One thing I do want to mention, that the lobbyist sends out a weekly report to Kathy, and Kathy will forward that report to you during the session if you just ask her to do so. There are a couple of other bills. One is about home-based businesses. We're not sure whether that will actually have any impact on restrictive covenants. Another one is about parking. Again, these bills sometimes can be broad enough that we monitor them to make sure that the parking issue is not something that would impact our restrictive covenants, but those are the kinds of things that the committee does and our lobbyist does. So that's the end of my presentation. Thank you very much. Good luck to all of you.
Thanks, Rod. I'm now going to invite everybody to come back on to share your screen and unmute yourself so we can start taking some questions that we have. Patrick, can you help with some of the questions? I'll start the first one. Can I invite everybody to come back? Rod and Malika, can you both come back in too, please? Thank you. First one, if pets are allowed at an additional charge per month, can that fee be charged for emotional support animals as well?
No. Emotional support animals are not considered pets, and so the association cannot charge the pet rent.
Great. Next one, aware of any cases or instances where a resident can request multiple emotional support animals?
Yeah, I saw that question. There is some guidance from HUD that specifically addresses that. And that's that 2020 guidance I was talking about from last year, where most of the requests obviously just involve one animal, but let's say a person has a disability related need for both animals because they provide different types of relief to that person. They can have two. They need to provide a letter, a doctor's letter for both different animals, explaining the need for each different animal. And then also if there are two individuals living in the unit and they each have a disability and a related need for that support animal, and they have the proper documentation, they can both have an animal.
Yes, I've had a complaint where a tenant requested 6 cats, and I had to provide her with a no-cause recommendation because she could not provide a nexus for each of the animals. Her doctor did send me a letter in which he attached each cat's name with an impairment, but I had to explain to the physician that that was still not adequate. It was not, even though he could attach it to 6 cats, 6 of the same type of emotional support animals, it's just not going to fly. You know, it's not we would not consider that a violation. So you are correct. Normally, more than 2, we take a real close look at.
Right.
Okay, so if a condo community has a 25-pound limit for their pets and a homeowner presents a web-based form, I think you guys talked about this earlier, I'm pretty sure, for an emotional support to keep a 120-pound dog, does the board have to accept that large animal when the homeowner could just easily have gotten a smaller dog for that emotional support? This is from Susie Bishop.
So based on the fact that the documentation provided was just a web-based form, that's kind of vague. But we talked about the internet letters just pulled off the internet that people perhaps pay for, those are not by themselves sufficient. I think Malika mentioned that too. They're not sufficient to document the disability and the disability related need for that specific animal. Now, let's say that person does in fact provide the appropriate documentation. The fact that there's a 25-pound limit and they're requesting or already have this 125-pound animal, it doesn't matter. They can have that animal in the unit as long as, I guess, Malika, if you could comment on this, if it is not inhumane to keep an animal in that space.
That's correct.
Right. And so if it can fit in there, and it's reasonable that it can fit in there, then yes, you have to allow that animal. If it's too large for the space, or it's like 500 square foot condo, and that animal is just way too large, let's say a horse, it won't work out.
Right. A miniature horse, and a lot of, there has been actual case law where tenants have requested to have a miniature horse. And if there is enough space, and a lot of that's going to rely on the city ordinances. So, you know, the Fair Housing Act, while we would like for that tenant to be allowed to have the animal, if it's against an ordinance, again, we have to take a look at those ordinances and determine, make a case-by-case basis. But yeah, even if the dog is over limit, you would be required, we suggest that you go ahead and make the reasonable accommodation.
Okay, we have another question where I think Sarah talked about the civility, CAI portion of adopting some type of civility rules. This is an interesting question that a manager is posing. It's basically saying that there's some board members and residents via email or just bad mouthing several residents, negative talk, that sort of thing. Is there anything a board can do to stop this type of negative communication that's spreading throughout the community, even if it's not true? Is there something that they can do? And then what's interesting is this one particular homeowner is planning on running for the board. Is there can the existing board deny a person from running on the board?
Well, so this comes back to what are the tools available to the community? Every community might have different tools. And we all know that everyone's governing documents read differently. One might have, you might have a civility type clause in your actual documents. And so if there's a clause like that in the documents, then this potential board member would be in a state of violation, and would, if there's also, you must be a member in good standing clause in the documents, well, then he would not necessarily be in good standing. So it's very difficult to answer questions like that without seeing the documents, because everything is so case by case, and what one community might be able to do is not necessarily the same as what another community might be able to do. I would encourage this particular community to try to do something, absolutely, because even if it's not going to result in a HUD complaint, because perhaps there is not, I can't imagine that there's no one in the community of a protected class, but even if it doesn't result in a HUD complaint, it sounds like it's creating a hostile environment with tension and unrest. And so back to protected classes, because it follows up on the next question. Do these points only apply to protected class? So I'm just going to roll right into that.
Yeah.
So if one is a member of a protected class or not, remember how Megan and Malika both explained, you don't necessarily know if someone is disabled, right? The disability could be non-apparent. And even if it's a white male, he could be a recovering alcoholic and he would be a protected class. So you just cannot, you can't make those evaluations blankly. So that would be all things to keep in mind. You know, well, they're not from another country. They don't have brown skin. They're not a family. They're not a woman. They're, you know, like you think that you can rule out all the protected classes, but you just can't.
You know, Sarah, I think what the point here, or maybe one of the point, and I might be jumping into it, is if the board is responsible, or is the board responsible if they're aware of some type of harassment, are they liable? I think that's kind of where they're going with that. Do they have some type of duty to act or to respond in any way?
Well, I think that, like I said, they should meet with their attorney to evaluate what can we do here? What can we do in a situation like this? What do our documents allow us to do? I mean, yes, I think that a board has a duty to enforce in any way they can to maintain the safety and the well-being of the community. And if you're noticing a toxic situation that is getting worse, you should do something to mitigate that.
Sarah's right. A lot of times that will lead to a toxic environment, will lead to a fair housing complaint. And that's something that you don't want to have to deal with.
Okay,
fair,
maybe.
Fair housing or not fair housing. Who wants to live in a toxic community? No one does. No one does. So yes, they have a duty in that sense.
Jennifer Jackstead has a question in regards to reasonable accommodations in writing. So if you don't have a reasonable accommodation in writing, how is it a housing provider to prove that request took place?
Repeat the question.
Okay. Without a request for a reasonable accommodation in writing, how is a housing provider to prove that request took place? What's to stop someone from claiming that they've asked for an accommodation when they really haven't?
Okay, this goes back to documentation. When someone makes the request, I would always, as the housing provider or the management company, I would document. You know, a request was made on July 15th for an assist animal. I informed the tenant or send a letter to the tenant stating, yes, your request for reasonable accommodation has been approved. That way you have some documentation showing that the request was in fact granted.
Okay.
So I would add to that too, that if there's in fact no request made, if the management or the board has a policy across the board how they handle these requests generally. And it's you know, a written policy that we get the request either verbally or in writing. We document it in here, we review it with the appropriate people, and then we do X, Y, Z. If that procedure is a written policy that's implemented across the board, and then this person claims that they made a request at some point in time, but you don't have that documentation, I think that, and correct me if I'm wrong, Malika, that will go a long way with HUD showing that you do in fact document these requests appropriately, and we don't have one from this person.
Right, absolutely. Because when I come on site and I start, reviewing your documentation, that's the first thing I'm going to ask for. Do you have a reasonable accommodation policy? I'm going to make sure that you, in fact, followed your policy and you have followed your policy with other tenants who've requested reasonable accommodations, if there have been any.
Right.
Okay, someone's asked to confirm or reiterate, let's talk about the adult swim hours. Is that really considered discriminatory to have some type of adult swim or a time variance where only adults would be able to swim in an HOA pool?
You want me to handle that one?
Yeah, anybody.
Okay. Yes, it would be considered discriminatory because you are restricting it to adults only. And that would be against, that you could have a complaint filed in violation of familial status. You're not allowing, you don't have a swim time for just African Americans or just for another protected class. That's why I said a good way to indicate or to see if you're discriminating, supplement or replace one protected class with another and see if it works for you. You would not have, now again, you can have the swimming pool available to children who are, a reasonable age. You want to have least restrictive policies, especially regarding families with children. So no, I would not, if I was a homeowner provider, I would not have an adult swim.
Well, let me ask you that. When you mentioned, I think in one of your slides too, that you talked about membership, or it doesn't, I guess HUD rules do not apply to membership class,
organizations that have housing restricted to members only.
Yes. So in an HOA world, they're not really a housing provider. There are pools that are in the HOA subdivision that is a asset or a common element for their members that are in good standing. So does this still apply in this situation?
Yes, a person could still file a housing discrimination complaint based upon familial status. Like I said, the department has initially they would have taken that complaint and ran with it. But now that we're seeing more HOAs having restrictions as far as the age limit, that's a little different for swim. But making a blanket statement such as this is it would be the same as advertising for a property as adult only property.
Okay.
Malika,
If they have, there's a follow-up question related to this in regards to if they have multiple pools. So if they have one pool designated for adults for like quiet and not to get splashed on, and maybe the kids are in the other pool, but it's in the same community, would that be okay, or would they be cause to get a lawsuit in that case.
That's still discriminatory. It's
Really?
segregation. You're segregating people based upon their protected class.
Okay.
Well, yes, that would still be considered discriminatory.
So I had a recent case involving that exact situation. The community had two pools. One was the adult pool and one was just the regular pool. And a person did file a complaint with HUD based on familial status. Fortunately, we revised the rules prior to any really official action or you opening the pool for that summer. So it was no damages were incurred by that person. So HUD did not move forward with the complaint. But it was, if we had kept the rules as they were, that would have been a viable discrimination complaint.
Okay, we've got one, I guess our last question comes from Jim Roopson, and he's one of our local St. Louis insurance experts. Some directors and officers' liability policies include discrimination coverage. This, I think, was one of Rod's statements to check in with your insurance company about coverages. This coverage is typically excluded on the commercial general liability policy, so it's important for boards to secure a D&O policy that meets CAI's best practices for coverage. CAI has some good online resources regarding critical coverages in the learning library.
Thanks, Jim, for sharing that. That's good information.
Kathy, looks like we got one question that just popped up from Jennifer.
We've got a couple more. Yeah, we have quite a few more.
Oh, really?
One that just
We're at
popped
the
up
top of
was,
the hour.
can a homeowner keep a trampoline if they say it is required for their disabled child, even if the documents state trampolines are prohibited?
Want me to take this one?
Sure.
If this tenant or this homeowner can provide documentation from a healthcare provider, and keep in mind, it does not have to be a physician, a primary care physician. It can be any type of healthcare provider. It has to be a legitimate healthcare provider, and there has to be a nexus between the request and the disability-related need. As long as all of those things are addressed, I advise, and I'm not an attorney, but I do tell my homeowners and housing providers to attempt to make the reasonable accommodation request.
Okay. I see I see where I've got these other questions here. One in regards to fraudulent possession of a disabled parking permit, where there is no evidence of a disability. What about those? I guess this person, Jay, is asking about, is there something the board could do in that case?
Are they aware that is actually fraudulent? This person does not have a disability-related need for this particular parking space?
Yeah, I don't know how a person, it just basically looks like he is stating that there's no evidence of a disability, but they've got a parking permit, disabled parking permit. And I guess the board is wanting to know what a board should do about that situation. I don't know about that. That's all he wrote.
Well, I think that, again, you don't know why someone has that, why they have that. You don't presume that they fraudulently possessed it. I mean, there are a lot of health conditions that would qualify someone to get a handicap tag.
And that may not be readily apparent to
Right.
you just by looking at them.
Right. It could be something like maybe they're prone to fainting or, have some kind of heart condition. And you know, they need to park closer to wherever they're going. And you would not know by looking at them that they have that internal condition going on. So I don't think that it's fair to presume that someone fraudulently possessed a handicap tag.
But you would need more details regarding what was actually going on. What made the housing provider believe it was fraudulent?
Right. And I don't know, that's probably a misdemeanor or something. And I don't know who you would report that to. Someone. You'd report it to someone and they would enforce that.
We're touching a lot of questions on the pool areas. I guess we've got a lot of active questions about that. If a community has 3 pools, a main pool that all family members can swim, a waiting baby pool for only children up to a specific age and height, and an adult only pool, would they be considered discriminatory? I think what I'm hearing from Malika is yes, but so if I want to get in the baby waiting pool, but I get kicked out, I guess I've been discriminated again. I guess that's what you're saying.
Well, not necessarily, because you're not a protected class.
But we don't know that he's not a protected class.
Well, I mean, I know Patrick and I know he's not, but if,
But what if you wanted to get in that waiting pool, Megan, and you're not allowed to? You're a protected class.
right. And so, I mean, yes, it's discriminatory to have these restrictions, just like it is with 2 pools. But Patrick specifically would not have a claim. But let's say a family of, you know, a couple and then a baby got in the adult swim pool and they were kicked out, that is a violation.
How does Lisa has a good question. How do we get around the 55 and older communities where these master communities, large communities, have like you have to be like in Florida, for an example, there's 55 and older communities. How is that? How are they getting away with that? Even the condominiums or apartments.
A lot of those properties, well, some of the ones that I'm aware of receive federal funding. So they have a special designation as a 55 or older property. That's how they can get away with.
Oh, okay.
Yeah.
There's special exemptions for those type of communities.
What kind of insurance should a management company have for a HUD complaint? And I think I answered that with Jim's, but I want to ask that for sure, just to get an idea. Maybe we had one complaint after a long discovery period, and thousands of dollars later, we prevailed in the fact that we did not discriminate. We could easily prove we implemented land use restrictions fairly and consistently. Now we received another complaint. I'm not concerned because we will have no problem proving that we did not discriminate. However, it is such a costly and time-consuming event. How do we have very high insurance coverage? We have very high insurance coverage. I didn't turn to them on the first claim. I was just wondering any additional insurance we should have.
I would ask my insurance agent.
Yeah.
If that person can email me privately, I can send them some information to contact certain insurance agents if they'd like. We need to kind of wrap it up. So we can only answer like 2 more questions that I see. I apologize.
You want to take those, Kathy?
Yeah. So I got, what if we do not permit estate or garage sales due to our narrow and private streets? Do we have to allow for passes, and can we move to not permit porch pickups if they do an internet estate sale.
I'm not sure how that's related to a discrimination complaint.
Yeah.
I mean,
Yeah.
that would be just a general analysis under the governing documents, I think, with your attorney.
Okay.
Okay, last, I'm sorry,
Yeah,
go
I was
ahead,
going to
Patrick.
say this one, because I think there's someone that's not clear on something, and they want to clarify proof of emotional support animal. Can you just clarify that one more time? How can someone, prove that they really need that? I guess they're concerned about fraudulent support animals. Can someone just talk about that real briefly and kind of sum it up and close out the presentation today?
So basically, they need some evidence that there is a disability and that they need this emotional support animal to alleviate a symptom or effect of that disability. And usually that'll be a doctor's note that has all that information included in it. If you are presented with something that you don't think is legitimate or really meets the requirements that we talked about today, definitely have a discussion with your attorney and send it over to them, and they can help you walk through the steps and see if all the requirements are met in that documentation. But there is a lot of fraudulent requests out there, so it's always good to be cognizant of that, and that you need to review the documentation and not just take it as face value.
And again, our office, the Office of Fair Housing, is willing to provide any technical assistance regarding requests for reasonable accommodations. So I will give you our general number, and I will also forward our 1-800 number to Kathy. I can't remember it offhand, but I will gladly give you our number, and any of the investigators that you speak with on that line will be able to assist you.
Great, thank you so much. And I will share that. I know we've got a lot of questions if we're sharing the slideshow and the CEI documents that were discussed. I'll share all that with you guys, no worries. Just wanted to do a couple quick housekeeping things. First of all, thank you to all the presenters. You guys did a great job. We appreciate all of you very much. Wanted to remind you guys about our next webinar, which is May the 12th. It'll be the second Wednesday next month, 11 a.m. again. Effective communications and good habits in today's world will be that topic. And I had the pleasure of visiting with Mr. Martin Notiff this week, and he has just published his 7th novel. I don't know if you guys can see it with my virtual background, but it's called Magnet for Murder. And he was nice enough to give me 2 copies to donate today. So I pulled 2 names, and we have Sally Barnett and Mike Keller that won 2 copies. So I'll drop those in the mail to you guys. Thank you guys for being here. We appreciate everybody. Sorry we couldn't get to all the questions. We hope to see you guys next month on May the 12th. Thanks, guys. Have a great day.
Thanks.
Hi, everyone. Thank you.
Bye, everybody. Thank
Thank
you.
you.